Hello, everyone. My name is Kelly Young. I'm a legal counsel with the Justice Collaborative. Welcome and welcome back to some of you to the latest installment of our Blueprint webinar series and our last one for the year. For our newcomers, the Justice Collaborative's Blueprint for a Safer and More Just America is a comprehensive framework for national criminal justice reform and outlines concrete steps to address the country's mass incarceration crisis and provides actionable solutions to creating a fairer and more equitable justice system. And to start, I cannot stress enough how grateful we are to our justice volunteers. Since we began in February, you all have stepped up and done amazing work. Thank you so much for that. You've researched and raised awareness about the injustices throughout the criminal legal system and have taken critical steps towards ending them. And really, we need you to do it again. As many of you know, a lot of the criminal justice advocacy lately has been centered around Rodney Reed, an innocent man on death row in Texas who is scheduled to be executed in 1 week. Towards the end of this webinar, you'll hear from Molly Bernstein, our Associate Director for Volunteer Research and Advocacy, about how you can join us and take immediate steps to try and stop that from happening. One of the key principles in our blueprint is to allow people to change and grow. And the death penalty not only denies a person's ability to change and grow, it deems it irrelevant. And it makes permanent all the injustices we've talked about over the past few months. From innocence to redemption, the perspectives on ending the death penalty are many. And while we won't be able to dig into all of them today, our panelists will take us from its origin as a means of legitimizing racial terror to the enduring systemic failures that persist despite constitutional limitations. And so joining us today, we have Brooks Emanuel, legal counsel at the Justice Collaborative, Derrick Jamison, peer specialist at Witness to Innocence, Ngozi Ndulue, senior director of research and special projects at the Death Penalty Information Center, and Liliana Segura, investigative journalist at the Intercept. Thank you all for being with us. And as we start the discussion, for all of you tuning in, if you have any questions, please feel free to write about them in the comment box along with your name and where you're from. And if you're watching on Facebook, please do the same there. And we'll do our best to get to as many of them as possible. I also encourage you to tweet during the webinar to share your reactions and what you're learning. And so normally we begin the discussion by framing the issue and talking about why we should care about it. And the death penalty is a little different because for the most part, we know why we should care. It's very visceral. And so what we'll have our panelists do is start the conversation by discussing the historical context surrounding the death penalty's introduction into this country's criminal legal system and the myriad disparities that accompanied it and continue to accompany its practice. And so Brooks is going to get us started with that conversation.
Hey, everybody. Thank you so much for joining. And as Kelly was saying, we'll talk more about Rodney Reed later in the call. Also wanted to flag for someone another upsetting piece of information. I'm in Georgia, where I'm born and raised, and Georgia is set to execute a man named Ray Cromartie tonight. Different issues than in Mr. Reed's case, but DNA evidence that if examined, that has been not examined, and if it were examined, could prevent his execution. And so I bring that up and talking about Mr. Reed, all of these issues that we're talking about, it's incredibly important to understand where they come from historically. And there are lots of pieces we can talk about, but I think the most important to understand is the modern death penalty's connection to racial terror lynchings in this country. And so just for time's sake, we are going to start after the end of slavery, after the Civil War and the Emancipation Proclamation, the 13th Amendment. Although there is a really quick flag that the 13th Amendment, which abolished slavery, for those of you who are not totally familiar with this, and most of us aren't because we're not taught, it abolished slavery except as punishment for crime. And so it is perfectly legal to enslave someone in the United States if you've convicted them of a crime. We're not going to get into it today, and please don't Google it now, but write down convict leasing and look it up, because it's a very clear example of how we went from slavery to the criminal legal system as a way of controlling Black people in this country and enforcing white supremacy. But the death penalty also plays a very specific role in the use of the criminal legal system to enforce white supremacy in this country. And so what you have is that after the end of slavery, you have some very brief successes of Reconstruction that should be talked about more. You had, when you had federal troops in the South and you had some federal civil rights legislation passed, there was a brief period where Black people's right to vote was protected. We actually elected our first US congresspeople, Black congresspeople, US senators. But very quickly, the troops were pulled out. The Supreme Court kind of gutted those civil rights laws, and things went back to, in some ways, similar to where they were under slavery. And part of the way that that happened was through this massive campaign of racial terror lynchings against African Americans. So what you have from the end of the Civil War in 1865 to around 1950, you have over 4,000 African Americans lynched in the South in racial terror lynchings. And EJI, Equal Justice Initiative, has done a lot of work on this. I would encourage you to visit their website. I used to work there, full disclosure, so I have a fondness, but they do really good work. But what's important to understand about racial terror lynchings is we're not talking about the Wild West, where you have a non-functioning justice system and the way that you deal with crime is you lynch somebody because there's no judge or anything like that. These are states with fully functioning justice systems, but it was deemed too good for Black people. The other piece of it is not only is it deemed too good for Black people, but racial terror lynchings served a very specific purpose of trying to regain the control over Black people that was lost at the end of slavery, and again, reassert white supremacy. So you have this massive campaign of racial terror for over half a century. But partway through in the 1950s, 1915, around 1950, 19-teens, 1920s, you've got the success of anti-lynching activists like Ida B. Wells. You start to get national attention on the South from the rest of the country, and people are realizing like this is not necessarily what we want America to be. There is actually the threat of a federal anti-lynching law. And so what the states start realizing is, oh, like we may have trouble continuing to lynch people with impunity outside of the court system. So we might want to move it to the court system instead. And so you have a very specific transition from extrajudicial lynchings to what many people have called judicial lynchings in the death penalty, where you actually have legislators standing up on the floors of state houses saying, we need to find a cleaner, prettier way to do this because they're not going to let us keep doing it the way we have been. And so in 1915, you have the first year where court-ordered executions, right, which we would call the death penalty, there are more of them than there are lynchings, extrajudicial lynchings in that year. 2/3 of those executed in the 1930s were Black. And so you see how lynchings go straight into the death penalty in that we just start executing Black people at this incredibly rapid rate. Over the next 40 years, from 1910 to 1950, the Black population of the South falls to 22%, but 75% of those executed in the South are Black. In Georgia, where I'm from, leading up to a case called Furman, which we'll talk about in a minute, in the 50 years leading up to it, just to put concrete numbers on it, Georgia executes 337 Black people, 75 white people. And there are also characteristics. One thing I forgot to say about the racial terror lynchings is they were designed to terrorize entire communities. And I apologize for getting into these things, but often bodies were mutilated, people were tortured. These things happened in very public ways. Bodies were often put, displayed, hanged in Black communities to terrorize the communities. And what you see with these executions are similar things. Sometimes even when states said they wouldn't do public executions. When they were executing Black people, there would be large public executions. Sometimes courts would congratulate themselves because there would be a lynch mob outside the jail or outside the court, and they would literally be going to the lynch mob and saying, hey, you guys back off, we're gonna handle it. But the point was, we're gonna kill this person, you're gonna get what you want. They're not getting a real trial. Very quickly, one example, which again, I apologize for how brutal it is, but I think it's important to talk about. At the beginning of this period, or during this period, 1944, George Stinney, young African-American boy, 14 years old, South Carolina. He's 14, he's tiny. If you see pictures of him, he looks like 10. He looks like a tiny child. 2 white girls are brutally murdered. He actually helps law enforcement by saying, I saw them go that way. Because of that, they decide they're gonna execute him for those murders. He is arrested at 14 years old. Within 3 months, he has been executed after a 10-minute trial. He is so small that they have to put books under him to attach the electrodes from the electric chair to him. And so I know that's really brutal, but I think it's really important to talk about how the modern death penalty started, and that's how it started. And now Ngozi is going to bring us into the current day and what it looks like now.
Hi, thank y'all. Can you hear me well? Yes, great. I am going to talk a little bit. I'm at the Death Penalty Information Center, and we work at the kind of intersection of the information and analysis on the death penalty. So we don't take a specific stand on the death penalty, but we look at where the facts lead us here. So Brooks gave a really great explanation of how through history the death penalty has been linked to race. And I think we have a lot of evidence about how much race and racism continues to affect the imposition of the death penalty today. So I'm going to try to share my screen, and we're going to see if this works. Let's see. One second here. Okay, we might not be sharing my screen at the moment since we're having issues. One of the things that we know about the death penalty is how much it is impacted by race today. So if we look at the people who are on death row, what we see is that it is not proportionate. So we know that right now, about 40% of the people on death row are Black, about 13% are Latinx, and then 42% are white. Now, so this isn't proportionate as far as the number of people who are who are going to be in the general population. This isn't proportional in regards to the number of people who are committing crimes that you can get the death penalty from, homicide crimes. So one of the things that we know about, both about who's on death row and also about who is being executed, is that race continues to be a factor in who those folks are. When we're thinking about executions, we also see disparities in the number of people who, Black people who are actually facing the death penalty. But one thing that we're not, that it's not just about the race of the defendant, it's often about the race of victims. And as Rick was talking about, when we're thinking about the history of lynching, we have this idea about kind of interracial crime ending up having a different and harsher punishments is when there's a white victim. So there have been a lot of studies throughout the years, and we continue to see this today, that when there's a white victim, you have a higher likelihood of getting the death penalty. So we continue to see this with the people who have been executed up to date. So as of now, if we're just talking about places where there was only one victim, we know that about 290 people have been killed in interracial crimes for killing Black people, but only 21 for killing white people. So we know that most crime is intraracial, right? So that people, people talk about Black on Black crime, but what is that? Because most crime is Black on Black, Black or white on white. But we know that there's this specific issue of extra punishment that happens when there's a white victim of crime. And we can talk more about that if there are more questions there. Another thing where we see race playing a role is in the actual functioning of the justice system. So we can see places where we're just like, well, the numbers are showing us. And Brooks will talk about some court cases that really don't take those numbers into account. But we see places in the numbers that say, wow, there's something different. But when we actually look at decision-making by people at different stages of a capital case, we're also seeing specific areas where we can see a difference between the treatment of Black defendants or in places where specifically where there has been a white victim. So one of the things that we look at in addition to race is also thinking about what is the use of the death penalty looking like throughout the country. And we see that just because we have a death penalty throughout the country, and when I say a death penalty, we still have different practices and different in different locations. However, the practices that we see in those different locations are very concentrated. So across the country, 21 states have abolished the death penalty. 4 states have not abolished, but they have a moratorium, which means that there will be no executions under the current governor who is imposed the moratorium or continued the moratorium. But in the places that actually still are executing people, we're seeing those executions happening in short, in specific places that are not where it's very geographically concentrated. So that's a focus that the death penalty is very much a state and local issue, and where state and local actors have a huge impact on whether the death penalty will actually take place and be used in that area. And so what we have done with our report about the 2% report, which we will be updating soon, is noting that only 2% of the counties across the country are actually accounting for more than half of death row. So we've actually found even more concentration of that, where it's even less than 2% accounts for more than half of death row. We're also finding that when we're talking about who's being executed, we have, if you go to our website, we have a page that talks about executions by county. We note anyone who's in Texas, of our top 10 counties, there are a number of those that are Texas counties by the number of executions, but we're also going to be looking at per capita and looking at larger counties, mid-sized counties, and which ones are actually executing the most. But the bottom line is that Death penalty it can be very geographically focused. It can be impacted by the actions of your local prosecutor, which we'll talk about more, the governor, your state attorney general. And there is just a wide difference in who is being actually convicted and sentenced of capital crimes and sentenced to death, depending upon where the crime happens. We can also talk about just generally how much the use of the death penalty has changed over time. And so often, you know, people talk about the death penalty as if, you know, it's kind of a given that it will be used. And some people talk about the idea that there's a deterrent effect. Well, studies about deterrence have not shown the death penalty to have a deterrent effect. And I think that there's a lot of evidence to say really the death penalty is not making it less likely that anyone that murders are committed, that you know, crime is going to go high. So instead of that, what we do find is that the way that people are using the death penalty is reflecting the way that people are talking about crime in this kind of tough on crime era, right? So as we talk about the connection between mass incarceration, so at the same time that prison populations are skyrocketing, that people are passing these 3 strikes laws, that people are campaigning on this tough on crime policies, which really had their peak in kind of the mid-90s. At the same time, the number of death sentences that were being imposed were having a peak. So for us, the peak of the number of death sentences were 315. So in 1996, 315 death sentences were issued by judges and juries across the country. Right now, we're at a place where we're really at near historic lows. We have been under 50 death sentences a year for several years now. Last year, there were 43 death sentences. And the same trend, although it's kind of delayed because executions take place so much longer after people have been sentenced to death, but we are also, there was a peak in executions of 98 executions in 1999, and now we're in the 20s, right? So we're talking about the use of the death penalty in ways that kind of were reflecting this idea that, okay, we have to have the harshest punishment. We have to kind of make a statement. We're in that kind of same tough on crime rhetoric. And there are a lot of places in the US where people have recognized that the death penalty isn't making anybody safer, that it's costing more, that there are all these issues. However, so much depends upon kind of like the local and state work that is being done around, first of all, getting those facts and getting the information about those facts out there. And that's very much what Death Penalty Information Center is about, is gathering and actually showing those facts. But I think I've been talking a lot about numbers, and I want to make sure that we're not just talking about, you know, bare numbers and the political trends and racial disparities, but actually talking about kind of the human impact of what our death penalty system is doing. And so I wanted to make sure that Derrick Jamison has a chance to kind of share his story about his experience.
So it's on me. Hi, everybody. My name is Derrick Wayne Jamison. I'm the 119th death row exoneree in the United States. And as we speak, we got 166 men and women that's been exonerated in the United States. I was wrongfully convicted and sent to die October the 25th of 1985, which became the worst day of my life. And I sat on death row in Ohio for 14 long years before they carried out an execution. In 1999, a young man by the name of Wilford Berry, he volunteered to be executed. And I don't know why he did that, but Berry wasn't from Ohio, he was from Texas. And they went ahead with the execution. And since 1999, they executed 56 of my friends. You know, been like 56 executions since 1999 in the state of Ohio, and a lot of them guys was innocent, but I had 6 days of executions while I was on Ohio death row. They came to kill me 6 times, and most of them guys, when I met them, they weren't number kids. A lot of them was just teenagers, young people who made some awful mistakes that shouldn't have cost them their lives, shouldn't have to cost them their lives. But we are making a lot of awful mistakes with the death penalty in the United States. We got 166 men and women. That's 166 reasons why we need to end it. We got a thing called life without parole, or life, or either 30 to 25 years. We need to use that, because we make a mistake with this life sentence. We could go get this person out the cell and release them, but we make a mistake with the death penalty. We can't go release a person off the death row. And this country is so divided right now. We really should end on death penalty, and nobody should be allowed to say who should live or die in America. That's giving them too much power. We're making too many mistakes, and the death penalty is so costly. They spent all the millions trying to kill me, and I was innocent. It's happened to 166 other people. So we need to do something about the death penalty in the United States. We need to be a kind of genuine nation. We need to quit this violence called the death penalty toward our citizens. We're killing innocent people. We're making awful mistakes, and it's a shame that we're still using the death penalty, and it's almost 2020, and we're still doing this barbaric act toward our citizens. I lost so many of my friends, and I lost 56 of my friends, but that ain't including the guys that committed suicide. I lost a lot of friends that committed suicide on death row, and a couple they was innocent, but they was tired of suffering, going through these day of executions. They're gonna kill me, or they gonna kill me, or they ain't. They got tired of going through that, so they took their own lives. And a lot of people don't talk about that, but I lost a lot of people, and that destroyed me, but it destroyed my family. My family still suffering from the effects the death penalty had on us. I didn't die on death row, but the death penalty killed my mom and my dad. I know that for sure, because I saw how much they suffered, because I know how close my family was, And a lot of people don't know this, but out of the 1,505 people that have been executed since 1977, on every one of their death certificates, it's got homicide. That means state-sanctioned murder. So, we got people. The death penalty ain't doing nothing but making more victims. By me saying that, the death penalty making more victims. We don't need that. We need to do something besides kill our fellow citizens. We're making awful mistakes with these overzealous prosecutors and police officers. Because I was innocent, but I was like the media darling when I was on death row, because the homicide detectives and the prosecutors in my case, they would have 35 pieces of evidence. You only need one piece of new evidence to get a new trial. I got one of the worst cases in American history, And when I was in federal court trying to get a new trial, the prosecutor and the homicide detective, they pointed the thing at one another on who dropped the ball while I'm sitting here with a death sentence, But the same day I was sentenced to die, October the 25th, also became the best day of my life. October the 25th of 2005, I walked off the death row a free man. But I lost so many friends. They carried out 18 executions while I was on Ohio death row. And them were some of my closest friends. And I still cry about them guys and cats, because, they called them monsters. They weren't nothing but human beings. Young people that made awful mistakes. And, society didn't care about them. I cared about them. They became my friends. That's all I had. That's all I knew was the people on death row, for 20 years, 2 decades. But they killed 56 of my friends. And That's why I'm continue this mission to speak out against the death penalty, and I hope it be abolished in America one day, because we don't need to kill people no more. Our Lord and Savior, Jesus Christ, was executed at the age of executing. We make death penalties, so we need to stop. You know, like Rodney Reed, he's innocent, you know, but don't nobody want to admit to it. A prosecutor would never admit that they're wrong, you know. Even in my case, and all this stuff that they hear from my lawyers, they never admit that they're wrong, you know. So with that being said, we shouldn't have the death penalty because we're making too many mistakes. And thank y'all for having me on the panel. Next person. Hello?
Derrick, thank you so much for sharing your story. We're honored to have you here and honored to, hear your perspective. And I know that when Brooks was talking, he made a lot of apologies for how brutal and graphic the historical context of the death penalty is. But that's the reality. And even as you talk, that illustrates that continues to be the reality. And so it's really important that when we advocate for reform and when we hear stories similar to Derrick's, that we have that frame and that understanding of, why it is that we have the death penalty in the first place. And that discussion kind of takes us into the legal context of the death penalty. And as we know, and as Derrick's story illustrates, innocent people are sentenced to death, and more often than not, they are executed. And unfortunately, this is just one of many systemic failures of the death penalty. But before we talk about that, Brooks is going to walk us through how the death penalty has evolved through Supreme Court rulings.
Yeah, thank you, Kelly. And thank you so much, Derrick, for sharing your experience. I think it's something nobody can comprehend having gone through. So I appreciate just the courage to be able to talk about it. It's really important for people to hear.
Thank you.
So going to the legal side of things, we'll try to not make it too boring. There have been some successes historically with dealing with the death penalty on the legal front, but there are obviously been some major setbacks, which is how we end up in a situation where we still have the racial discrimination that Ngozi was talking about, where we still have what Derrick was talking about, that 166 people have been exonerated. And it's just so important to think about what exonerations mean, right? That someone went through the entire process that these states have set up, that the Supreme Court has said is constitutional, all of that. They are still convicted and sentenced to death, meaning the state is able to execute them. And then the process for getting exonerated is so difficult as well. There's every reason to believe that there are a great number of innocent people on death row. But as Kelly said, aside from innocence, there are all these other problems with the death penalty. So looking at legally how we got to where we are today, when we talk about the modern death penalty, we are talking about what started after 1976. That process, though, started in 1972 with a case called Furman v. Georgia. NAACP Legal Defense Fund gets a case to the United States Supreme Court showing all these things that we are talking about. And the court actually says, okay, death penalty is unconstitutional. They've shown how arbitrary it is. The lawyers showed how arbitrary it is in that you could take two people, same crime, same circumstances, nothing distinguishing. One of them might get the death penalty, one of them might not. And if you're talking about a penalty reserved for the worst of the worst, that's clearly not holding up to the Constitution. And they showed how discriminatory it was in the ways that we talked about earlier against both Black people and also poor people. Very quickly, what they did, though, was they struck it down in practice. Only two justices said that it was unconstitutional outright. Justices Marshall, Thurgood Marshall, and the NAACP Legal Defense Fund, and Justice Brennan said that it was unconstitutional outright. The other three wrote opinions. The other three people striking it down said it was unconstitutional as applied. At the very least, it was arbitrary. It was like getting struck by lightning. It was freakishly and wantonly imposed. This was language they used. And they said, you know, if you can, some of them went pretty close to saying, okay, it's definitely discriminatory against Black people. Some of them said, well, it's arbitrary, but if you can find any reason for it, it's probably discriminatory. Okay, either way, they get rid of it as applied. Huge victory. A lot of people think, great, death penalty is gone. Good reason to think that. However, the states instead, turns out, not to be too crude, but they really want to kill people. It's important to know that's what they're trying to do, right? They're fighting very hard for the right to kill people. And so they go back and they rewrite their statutes. So 4 years later, again, Furman v. Georgia was 1972. Gregg v. Georgia is 1976. A case goes back to the Supreme Court. And without getting into all the technicalities of how they say they fixed it, the states say, hey, we fixed it. We came up with a way. We're going to have a guilt phase, and then we're going to have a sentencing phase. It's going to be 2 parts, and we're going to have aggravators, and you're going to have mitigators, and you weigh the aggravators and mitigators to decide who gets death and who doesn't. And the Supreme Court was like, all right, cool. Like, you guys fixed it. You know, we made this major decision. We took all this evidence and said, clearly you guys cannot handle this. But looks like you got it. So go forth, you can start killing people again. And so unfortunately, in 1976, 1977, we start constitutionally, officially killing people again. The problems, of course, were not fixed. And so in 1987, in one of the really low marks in Supreme Court jurisprudence, NAACP Legal Defense Fund, who just should get so much praise for their work on these cases, gets back to the Supreme Court, again from Georgia. Again, I'm born and raised in Georgia. I'm sitting in Georgia right now. McCleskey v. Georgia. They get back to the Supreme Court. Ngozi alluded to these statistics earlier. They did this incredibly sophisticated study of the state of Georgia of death sentences since the death penalty had come back into effect, right? And after you corrected for variables that could have explained the disparities on non-racial grounds, right? They did this whole regression analysis that made everything equal so you could just look at the racial factor. There was a slightly higher likelihood if you were Black, a Black alleged perpetrator had a slightly higher chance of being sentenced to death than a white alleged perpetrator. But the really striking thing, which Ngozi talked about earlier, is that if you were charged with killing a white victim or convicted of killing, no, charged with killing a white victim, you were 4.3 times more likely to be sentenced to death than if you were charged with killing a Black victim. And so when you talk about Black Lives Matter, this is a place where very clearly the justice system was valuing white lives over Black. And so what that meant then, of course, if you were a Black person charged with killing a white person, you had the very, very highest potential for being likely to be executed. The court didn't throw out that study. The court said, oh, the study makes sense. We don't have any reason to question your study. Looks like you did a good study. Too bad, doesn't matter. We're not gonna allow statistics to say something is unconstitutional. If you cannot show us that an individual player in your case, a judge or a juror, or a prosecutor, specifically gave you the death penalty because they didn't like you because of your race, you haven't shown us discriminatory purpose and you're out of luck. And so as you can imagine, McCleskey is a huge obstacle when you're trying to make a racial discrimination claim in the criminal legal system context at that point. An important note about it is they also said, you know, if we let statistics in here, more or less, the court said, we let statistics in here to show discrimination, we strike down the death penalty, what will we do in the rest of the criminal justice system, the criminal legal system, when these statistics come in? I think that's a really good point. I think you would need to strike down a lot of other things as well. I think that would be fine. What one of the dissents said was that the court showed a fear of, quote, too much justice in that case. So 1987 is a big blow with McCleskey, and since then, there have been some smaller successes that rather than going at the death penalty outright have been chipping it away at it in various ways. So I'll go through just some of them quickly, just so to give a feel for it. In 2002, And very quickly, of course, we always talk about Supreme Court cases. There are state level cases and federal cases that decide some of these things, but the Supreme Court matters because once they decide it, it applies everywhere. 2002, you can't execute a person who is intellectually disabled. Of course, the court doesn't actually define quite what that means, and so they have to come back in 2017 and do a better job of defining that. Still not totally clear, but better. 2005, very, very important. Think about when, if you were to guess when the United States stopped executing kids, when would it be? 2005, less than 15 years ago. Roper v. Simmons, you can't execute someone for a crime committed when they were a child. 2007, you can't impose the death penalty for crimes basically besides murder. And then in 2016, actually we'll talk about that in a minute, but you can see how we start narrowing down where the death penalty can go. And these have been really important decisions for a few reasons. And so just one last thing to say about it though is, you know, a question has come up when you do this, when you narrow down where the death penalty can go, are you really helping get rid of it, or are you just sanitizing it so that we feel more comfortable with it? And I don't have an answer to that question, but there are indications that narrowing it down is helping us move towards abolition. First, we've seen pretty clearly the Supreme Court does not have a great interest in just ruling it unconstitutional outright without a lot of pressure. The court doesn't generally take big dramatic actions on their own, even with gay marriage, which was like one of the biggest dramatic decisions in our lifetime, or in recent years. A lot of commentators observed, yeah, well, they did that once the public was pretty much on board. You can look at cases like Gregg and McCleskey and all these other cases where specific things were challenged, but the court could have struck down the whole death penalty if they wanted to, and they didn't. The reason it's important it's being chipped away at, though, and the reason there's promise there is that when you're dealing with these cases, you're dealing with the 8th Amendment ban on cruel and unusual punishment, right? You're saying that death penalty violates the 8th Amendment's ban on cruel and unusual punishment. Supreme Court has taken that literally to mean cruel and unusual. So it doesn't matter how cruel something is, it has to be unusual as well. And so what they have started doing in recent years is this evolving standards of decency analysis. Don't worry about that term. Just look at unusual. They've actually started looking at numbers to determine whether something has become unusual enough that if it's cruel enough, it's also unusual enough that they can get rid of it. And one more piece of why these decisions are important is they have a broader impact on mass incarceration. So the Roper decision in 2005 saying you can't execute kids, that logic gets used in 2010, 2012, 2015 to start limiting the uses of life without parole for kids as well. And that's incredibly important because it's also an incredibly harsh punishment that we're basically the only country in the world that sentences kids to die in prison. And it's also really important if you were to look at those cases, if anybody's interested, that's the Miller v. Alabama line of cases, is the juvenile life without parole cases. You will see the court pays a lot of attention to how many states are sentencing kids to life without parole for certain things to see if it's unusual enough. So that is, you can see we've made some progress, right? But as we've talked about, a lot of the problems still remain. And Ngozi is going to talk about how we see those playing out now.
Thanks. Yeah, so Brooks talked about a lot of issues that the United Supreme Court or state Supreme Court has looked at. One of the things as we kind of monitor what's happening with the death penalty and what the death penalty developments, you see patterns about who ends up being sentenced to death, who ends up being executed, and problems that come up over and over again. So that the Supreme Court has said basically that the death penalty is supposed to be reserved for the worst of the worst, right? The worst crimes, the worst people, it's supposed to be this kind of limited pool of people. And oftentimes one of the things that we see is that instead of kind of the worst of the worst, like the most egregious circumstances about the crime or the person who did the crime, we're seeing the most egregious circumstances about kind of the process, right? So there are issues that come up about whether people are getting adequate representation. If you've been following the death penalty, we've heard cases of sleeping lawyers, lawyers who are later disbarred, lawyers who had active substance abuse problems, who were representing people sentenced to death. Some of the folks who had been, I think there was one person in Texas this year who was executed, and I think in Florida, who had lawyers who were cutting and pasting between one client to another, who were it was just very clear. And I think there was a particular person I'm thinking about in Florida where they didn't even remember to change his name when they were putting together this cut and paste pleadings for folks. So if we're thinking about the system where we're supposed to have constitutional protections, and we're seeing continually folks who have lawyers who are not even giving them kind of like the basics of defense, it's no surprise that you're also seeing other issues that are going unaddressed, like prosecutorial misconduct. So Derrick's case is one where there was a lot of evidence that was hidden by police and prosecutors. And oftentimes that goes hand in hand with a lawyer who, didn't, push for the evidence, but it's also just independently where we're seeing both police misconduct and prosecutorial misconduct that plays a role in capital cases. Some things that are specific to capital cases, Brooks talked about the Atkins versus Virginia decision, where the Supreme Court said that if you have intellectual disability, at that time they called it mental retardation, that like we as a society have decided that this is not an appropriate punishment. The death penalty is an appropriate punishment. But that question about, well, how do we decide for, if you have an intellectual disability? A lot of medical professionals are saying, well, we have, very specific criteria, and we look at the criteria and we see if somebody satisfies this criteria. But some courts have had said in the past, well, we kind of know them when we see them. So if this guy, doesn't, look intellectually disabled, doesn't seem intellectually disabled, wow, their crime took some planning. So clearly they can't be intellectually disabled. We, whatever those doctors are saying, we're really not going to credit that. And that sounds flippant, but there are some really concrete examples of that. The state of Texas is one, and I know we pick on Texas. Florida also had some issues there too. Let's be honest, just many states have had issues around this. Texas is kind of a high on executions and sentences, but there are a lot of the things that we're seeing as examples there are still going on in other states, just maybe in smaller numbers. I'll also note that there's races impact sometimes, whether people are seen as intellectually disabled or not, as far as people who have claims, and we're still seeing a racial bias in whether their claims are successful around intellectual disability. But Bobby Joe Moore's case is a case from Texas where the doctors are saying that he has an intellectual disability, but the Texas courts used a set of standards that were basically stereotypes about people with intellectual disability that was basically kind of based on kind of mice and men, like the Lenny character there. And the Supreme Court told them, no, you really can't do that. You need to actually listen to the experts and listen to the medical community about what the standards are. And so they sent Bobby Joe Moore's case back down to the Texas courts. And then the Texas courts again said, yeah, we understood what you said, Supreme Court. We're not going to do that anymore. But actually, all the same things. And again, he doesn't have an intellectual disability, and they sent it, said, no, he's fine. Until the US Supreme Court again said, no, he really does. Like he fits the criteria, and they finally, earlier this year, just recently said that he will get a life sentence instead of the death penalty. But so, we talked about intellectual disability, procedural issues around the death penalty. We also have those questions about kind of geographical and racial disparities. Another big piece I wanted to mention is juries and how juries, so both discrimination in picking juries plays a role in death penalty cases, and then bias in juries. And we've seen this recently in cases where folks have been executed. Charles Rhines in South Carolina was recently executed despite the fact that jurors who were deciding whether to sentence him to life or to sentence him to the death penalty knew that he was gay and said, oh, we don't want to send him to prison where there are going to be all those men. Like, we don't want to send him there for life. That's just like rewarding him. And despite the fact that that happened, he has at least a number of jurors, who agree that this is what they considered the fact that he was gay in deciding whether to send him to life or death. He was executed last week. So we really have significant issues. And I think it's important to recognize that there are significant issues that never really get addressed or remedied. We have folks like Rodney Reed, who has serious innocence claims that are happening. There was Larry Swearingen was executed earlier this year, and he had a very strong innocence case. There's Sedley Allen's Allie's family in Tennessee, who has already been executed, is still trying to clear his name. So I think that question of, like, we have a very kind of complex procedure around the death penalty, and people will say, well, there are ways to fix the problems, right? So we have these procedures. However, we're still seeing people being executed despite all the procedures that have been put in play. And that another important part is that oftentimes courts will try to use procedure as an out, not to grant relief. So that they'll say, yeah, he should have raised that 10 years ago, regardless of whether he had the cut and paste lawyer 10 years ago, or the juror only would speak to the defense team now that the execution date is approaching. So there's always, I think on one side of talking about the death penalty, there's this question about, oh, it's delay, and then at the very last minute, somebody's going to try to bring something up because they're just trying to stop this execution. But in many ways, there are these procedural roadblocks that have been put in place that actually stop people who have, like, valid claims for relief, and they stop the courts from even really considering those claims for relief. And that is part, actually, of our whole story of mass incarceration and tough on crime, because many of those procedural barriers came into play in those tough on crime 90s. There's one in particular, the Anti-Terrorism and Effective Death Penalty Act, which of course, is all about saying no federal court review for you for state prisoners, and saying we are going to defer to what state courts say, which seems like reasonable in isolation. But when you have some state courts that will take what the prosecution wrote as like a proposed findings of facts, will cross out proposed and say, here are my findings of facts. Then you go to federal court and the federal court says, well, that's what the state court found, so we're done. So those are some of the patterns that we see when we're looking at death penalty cases, and when we see the concerns that are coming up, and all of which have a lot to do with kind of transparency, the barriers to process, and also on the juror issues when we're talking about kind of bias and on the jurors and discrimination in picking jurors. If everybody's been paying attention, Curtis Flowers' case in Mississippi is a good example of that. This prosecutor who struck all the Black jurors he could, basically, from Curtis Flowers' case. Over 6 trials, kept on striking Black jurors, got smacked down from it for at least 2 times, still kept doing it, and the Supreme Court had to say no, and Curtis Flowers is still going to be retried again, I think with a special prosecutor instead of that specific prosecutor now, but that prosecutor ran uncontested, is still Doug Evans is still a prosecutor in Mississippi. So that talks about kind of the scope of the problem. But I will stop there because I could go on for days about all the different issues that come up in death penalty cases.
Thank you, Ngozi and Brooks. Because it's really helpful to have that context and understand all of those failings, and understanding that it is one part of the reform, and another huge part is the language we use. And so when Derrick was sharing, he called the death penalty sanctioned murder. And so why do we call it the death penalty versus that? And he mentioned that he was a media darling, which speaks to who we consider vulnerable, whose story gets told, and how. And so right now we're going to hear from Liliana, and she's going to talk about the role that the media plays in shaping and changing the narrative around the death penalty and who is sentenced to death and why.
Thanks. So can you hear me okay, everyone?
Yeah.
Cool. So I'm going to try to be a little bit brief so we can get to Q&A, and there's so much that's already been covered that's sort of awesome that I can draw upon. But I just wanted to start sort of by just giving a quick, anyone who's out there, a quick sense of sort of how I came to this issue as a journalist myself, and sort of why I feel comfortable and have always felt comfortable writing with a kind of point of view. Basically, you know, the sort of short version of the story is, you know, cases like Derrick's, stories like Derrick's are really the reason that I came to this issue as a journalist and have continued to focus on it in my work over the years. Basically, I grew up, you know, in a suburb of DC, immigrant family, not particularly impacted by the criminal legal system, didn't, you know, have direct, you know, didn't have loved ones who had been in and out of the prison system, hadn't been a victim of a violent crime, anything like that. So it really wasn't until college that sort of through a series of events, I kind of fell in with a crew of activists who were organizing a series of events on my campus. And at that time, this is 2001 or so, they did an event that I'll never forget that kind of altered the way I saw this issue forever, which was they did an event called Alive from Death Row. And it featured a man who was on death row in Illinois, who, when he called in, described how he was a Black man and described how he had been the victim of vicious torture by Chicago police, a torture that was aimed to extract a confession from him. And I believe in this case, a confession was, they did get a false confession. And this was part of a larger scandal over the 80s and 90s that somehow I had never heard about, but it was a sort of an open secret, especially on the south side of Chicago at that time, which was over 100 men, almost all of them Black, being systemically brutalized and tortured under a racist police commander named John Burge. Now, some of these men ended up on death row. It was in part because of this sort of issue that ultimately Illinois imposed a moratorium, and later the governor of Illinois cleared out death row. I believe it was in 2003, he commuted all the sentences, in part because he was so concerned about innocent people giving false confessions and ending up on death row. Now, when I found out about this, when I attended this event, and when I heard this man's story, who was speaking to us from death row, and when I heard another guest speaker was the mother of a man who had been tortured in a police precinct in Chicago, and she talked about how her son had called her that night from the police precinct and said, "Help, I think they're going to kill me here." You know, when I heard those stories, I was just completely appalled that I had never heard these stories before, that somehow this had not been a national scandal. This had never been on the front page of the New York Times. It is to the credit of some journalists who did end up exposing these stories. First among them was John Conroy from the Chicago Reader. But basically what it did to me was both radicalize me in terms of sort of this system as a whole, and understand that I needed to learn a whole lot more about what was going on and how people are ending up on death row and in prison. But also, I had always known I wanted to be a journalist, but I didn't really know until that moment the kinds of stories I wanted to tell. And I think that that's been sort of a touchstone for me professionally, because I think that part of what happened there, part of the tragedy and the injustice of that sort of piece of Chicago history, is that it was a profound failure on the part of the press and on the part of the media for not being present in these communities, for not listening to people who were saying that this was happening in their communities, and for just finding, coming around way too late to kind of, impose any kind of journalistic accountability. And so I wanted to share that with you because it sort of shaped how I approach these issues, but also because fast forward a few years later, one of the men who was pardoned ultimately from death row in Illinois comes to New York. I was in New York. He comes to New York to do an event that I helped organize. And he tells his story. This is a guy who had been wrongly sent to death row, accused, essentially framed, of setting a fire that killed his partner and his young child. He served something like 16 years on Illinois' death row. He tells his story. It's an incredible injustice, and it's really moving and it's upsetting and all of those things. And afterwards, I'll never forget seeing an NYU law student, a white guy, go up to him and say, thank you so much for sharing your story. But in the end, the system worked. The system worked. And I remember just watching, kind of aghast and thinking, oh my God, like, this idea that the system works is so entrenched. It is so deeply entrenched in us in ways that we don't even realize, that you can hear a story like that about a wrongful conviction, a tragic wrongful conviction and exoneration, and still sort of come away with this idea that, well, because he got out in the end, the system worked. And so that to me just spoke volumes about both the ways in which we sort of casually dehumanize people who actually are impacted and who are at the center of these cases sometimes, of both, those of us who didn't experience it ourselves, but also this need to combat this notion that the system works, when literally everything that's just been described over the past hour is evidence that the system doesn't work, and that in fact it's rooted in this sort of history of systemic, of racial terror lynchings and all of that. So I appreciated that you all were talking about that. Brooks, when he was talking about the sort of EJI work, I've been to the EJI Memorial and Museum in Montgomery, and I was actually just there this past weekend. And one thing that's so striking about that experience of visiting this place is that, and what's so important is about this story that it tells, this narrative that it presents, that's really pushing back against centuries of sort of insidious narratives specifically about Black people and Black crime, which is that it traces that line from slavery to the Civil War to lynching, that whole sort of history, and shows the connection and how we end up with mass incarceration and with the death penalty. And when I went down to Montgomery, when that whole museum and memorial was unveiled, something really extraordinary happened, which was that the Montgomery Advertiser published in spring of last year, I guess, in their coverage of this launch of this memorial and museum, published an incredible sort of editorial, which I've got pulled up here. And essentially it says, it was titled, I believe the online version, it was titled, sorry, hold on, Our Shame, the Sins of Our Past Laid Bare for All to See. And it starts with them saying, we were wrong. And they talk about how, they talk about the Montgomery Advertiser's role in helping craft this narrative that supported lynchings, this narrative of Black criminality, specifically of Black men who posed a threat to white women, and defending lynchings as a deterrent against that. And that's the same, justification we then see for the death penalty. It's a deterrent specifically, in the South, to prevent these Black men from attacking our white women. And so this editorial, they write, we take responsibility for our proliferation of a false narrative regarding the treatment of African Americans in those disgraceful days. And it talks about how careless they were in covering it, and how we dehumanized human beings. Too often we characterize lynching victims as guilty before proven and often assume they committed the crime. Now, I wrote a piece last year that was sort of delving into some of this stuff, and I spent a lot of time looking at archival newspapers from that era. And it's not just that they sort of made assumptions about people's guilt. It's that they described victims of lynchings in grotesque, animalistic, overtly over-the-top racist ways that was really stunning to read. And so I think that really speaks to the way in which the media has always been in a really powerful role, shaping these horrible, insidious racist narratives around crime that then give rise to policies like the death penalty, like mass incarceration, all of that. And I just have to say, one of the only reasons that we know as much as we do, and among the people who were fighting back in that era, is because of a journalist who was courageous enough to take this on, and that was Ida B. Wells, and because of Ida B. Wells, who actually dared to speak up and say, actually, those narratives that are being printed in the white press are false. This is the truth of what's happening. She had to flee her home and relocate up north in order to stay alive after doing that work. But it speaks to just how powerful journalism can be, for better or worse. So I appreciate that we're kind of couching all of this in these historic terms, and I don't want to go on too much longer, but I do want to talk about, one of the things that Montgomery Advertiser editorial shows is just how slow we are in the press to learn these lessons. It's like, now we're finally at a place where we're questioning, maybe the tough on crime era of the 80s and 90s was a bad, maybe the press did a bad job, in all its fear mongering and all of its willingness to kind of write these really sensationalist stories, playing up, crimes and creating, contributing to this idea of the super predator, right? The juvenile super predator, which is why we needed to treat children as adults. All of that, we're only just starting to reckon with those false narratives and the policies that came out of those narratives, and the way that the press sort of shape those narratives, those more recent narratives, is unquestionable. There's my colleague Jordan Smith, who's she's done really more reporting than any journalist on the Rodney Reed case, which I'm really glad we're talking about, and which, by the way, is could not be more clearly linked to that history of sort of the dynamics between lynching and the death penalty, a Black man accused of raping and murdering a white woman. Jordan, I was talking to her before this, and I was saying sort of, what would you say about what journalists need to do in better kind of covering the death penalty and these issues? And one thing she pointed out, which is absolutely true, is that, we discover all of these things about these cases, all these problems, all this misconduct, all these things way too late in the game. And when you look back, years later at what the coverage looked like of cases from, whatever era, the 70s, 80s, 90s, it's so often that, it's kind of straight crime reporting. You've got what police say, you've got the details of the crime, you've got this mugshot, and there's very little sort of effort oftentimes to kind of approach the arrest, the investigation, the trial with any kind of skepticism. It's very much kind of straight reporting without a whole lot of interrogating of the facts and whether or not, the state's case really makes sense. Journalists, I think, are very reluctant to kind of do that until oftentimes it's too late. And so Jordan's sort of take on this is that journalists need to be a lot more skeptical from the beginning, because failing to do so is how we end up with wrongful convictions. It's how we end up with people facing execution dates and all this stuff coming out later on about, the trauma they experienced as a child, the racism of juries, things that should have been an issue from the very beginning. It's an easy way out to kind of blame the courts or blame lawyers for failing to kind of bring that up. Journalists have a job to do there too. So I don't want to go on too much longer. Maybe I'll just end with just some common misconceptions that I think lawyers understand, but that journalists are often hesitant to kind of take on. But I think it's really important to contextualize the system. The Anti-Terrorism Effective Death Penalty Act was brought up earlier. I can't tell you how many times, a few years ago, I decided to just write a big piece about that law and how it came about, because it comes up in every case ever, but also because it's so poorly understood. And there's this really common misperception among the general public that, people on death row are constantly escaping execution because of a technicality. Everyone gets off on a technicality, and when in fact, laws like that one, laws that put procedural barriers to relief, often ensure that people are actually, as David Dow, a death penalty lawyer in Texas puts it, people are often executed on a technicality. You know, these procedural rules that stand in the way of sort of relief for people often grease the wheels towards execution for people. So I think that the sort of notion of technicalities is something that people on death row can kind of take advantage of unfairly is really something of a myth in my view. The other idea is, you know, this idea of endless appeals, that people on death row have endless appeal after appeal after appeal, and they're constantly escaping execution for that reason. There isn't enough of an effort, I think, in the media to grapple with some of the real underlying reasons for these endless appeals, which is as much on the state side. It's courts don't have, you know, courts take months or years to rule on appeals. You know, offices are, there's backlogs in different jurisdictions. There aren't enough qualified post-conviction defense attorneys to deal with these cases. And so I think that needs to be, you know, highlighted. And you know, finally, we sort of saw recently when the announcement was made that federal executions were going to restart. You know, I think it was an important moment for the media to provide a bit of context, additional context. I think people don't really understand what federal death row is or how it's different from what's at the state level. You know, I think there's sort of an implicit assumption that maybe it's the kind of gold standard, or everyone on federal death row is a terrorist, which neither of which is true, like not even a little bit. So I think that that the media can do a lot better job sort of counteracting some of these narratives and some of these assumptions that have been deeply ingrained in us. And I'm happy to sort of talk about that further if we have time during Q&A.
Thank you, Liliana. And right now, yes, as you mentioned, we are running low on time, but I do want to hear from all of you about what you're working on and how, like what room is there for volunteers to be engaged in the work that you're doing. So Liliana, if you could start us off, if you have any ideas, that'd be great.
Well, the work that I'm doing, I might actually defer to other folks just to speed things up. I mean, I'm happy to drop in, but why don't we just, you know, I'll skip my turn on this for the moment.
Perfect. Okay, so then Ngozi.
Sure. So like I said, Death Penalty Information Center is all about kind of information and analysis on death penalty cases. And so right now we've launched a new website. You guys should really go play with it. Unfortunately, I could not get my screen sharing to work, but if you want to learn more about specific aspects of the death penalty, race, mental illness, intellectual disability, figure out how your county's doing on these issues, all those types of things, please, you know, check out the website, sign up for our newsletter. We do daily features that are summarized in the newsletter. I think that on the state and local level around the death penalty, like for us, information is so important, right? In the ability to know and understand more about the death penalty. So if folks specifically have, you know, the desire or interest to actually do some information requests, go down to some courthouses, get, you know, information about specific jurisdictions and what they've done in the past. We're working on a death row census right now, which is about all the people who have ever been sentenced to death and getting as much information about them as possible. You know, feel free to contact us, and we're you know, always happy to get that help. But I think that regardless of whether, you know, we interact specifically, the ideas about tying into what Liliana was saying about the great work that journalists have done, there's so much of the practice of the death penalty that is under wraps and isn't available for people to analyze, or is hard for people to analyze. And we are trying to make sure that people have as much information as they can about this. We just did a report on secrecy and lethal injection and how states have passed laws so that they don't have to talk about how they're killing people when they commit execution or carry out executions, and why this can be a problem, because to actually understand whether the punishment is cruel and unusual under 8th Amendment, a lot of how that is being carried out matters, but there are so many state secrecy laws that are inhibiting that. So working on kind of the government transparency piece is always very important to us as well. And I'm also going to take a moment. So first of all, yeah, check out our website, check out our resources. I also wanted to make some book recommendations. So Just Mercy, the movie's coming out, Brian Stevenson, if you haven't read it. Devil in the Grove by Gilbert King, I think does a really great example of explaining some of the things that Brooks talked about the intersection of race, power, and the death penalty and lynching in the past. Picking Cotton is a good one about wrongful convictions, and Jennifer Thompson and Ronald Cotton, and talking about mistaken identification in that case is really powerful. And then Anthony Hinton, The Sun Also Shines is another one about somebody who's been on death, or The Sun Does Shine, about someone who's been on death row. But I just figured for further information, there's so much out there.
Thanks, Ngozi. Brooks, do you want to go next?
Sure. So I work at the Justice Collaborative with Kelly. And so I know some of you are Justice volunteers already and have already done projects with Kelly. So I'll be very, very quick. We focus on holding elected officials accountable for criminal justice reform. And so we do a lot of work, especially focused on the role of prosecutors, because prosecutors have an incredible amount of power. They often have almost total discretion as to whether to bring charges, what charges to bring, what sentence to seek, and that includes seeking the death penalty. They don't have to seek the death penalty. And so, you know, if you can get prosecutors to limit the use of it, one, in that individual case, you're making a huge difference, but you're also making it less common, more unusual, and working towards eventual abolition. So I won't talk about the specific case. What I will say is there are a number of prosecutors around the country who are kind of just doing business as usual. There are some who are actually doing some good things and trying to limit the use of the death penalty. And there are some who are doing some really bad things. And in all of those cases, we try to put public pressure on them to do the right thing. And so in the ways you can get involved, we have research opportunities. You can help with public events to put pressure on prosecutors, and then a lot of amplifying through social media, online, of stories and events that are already happening. I think that's already happened with Rodney Reed stuff. And then another thing that's really important to do is let us know if you find out about something going on where you live regarding the death penalty. Let us know, because we may or may not already know about it, and there may be a way that we can help. Thanks. And thank you all for your attention, because it's really important.
Thanks, Brooks. And Derrick, do you want to talk about the work that you're doing?
Yeah. Well, you know, I'm the peer specialist with Witness to Innocence, and I just came off the tour with Journey. I've been on a Journey of Hope tour the last 3 years. They picked me and Deborah Donnery, Susie Graham the last 3 years to go on their tour with them. And I've just been doing a lot of speaking, and I got a lot of stuff scheduled for the future, and continue this abolition work, you know, trying to end this madness in America, and focus on good, you know. Other than that, I just got a bunch of speaking against mind, things of that nature. And I got a book that's out. I'm in a book called Deprived, Innocent on Death Row. The author name is Stephen Hill. It's a book with it's got 10 different stories in it. It's got me, Sonny Jacob. She was sent to die in Florida. She lives in Ireland now. And it's got Andy Gordon in there, his brother, Ronnie Gordon. He was executed by the firing squad in Utah. It's got his story in there, and it's got Marietta. I can't think of Marietta's last name, but her granddaughter was kidnapped by a serial killer, but the serial killer winds up committing suicide on death row. But she tried to keep him from going to death row, even though he had killed her little girl. Her story is in there. and a bunch of other stories. Herman Lindsay, he's a death row exoneree from Florida. One of my best friends down here in Florida. I'm staying in Tampa now. But I'm just trying to stay busy and keep speaking out against the death penalty and keep people focused on something better than the death penalty, you know? That's about it.
Derrick, thank you again so much for sharing your story and then for continuing to do the great work that you are doing. And so, yeah, thank you. And so right now, Molly is going to quickly talk about how you guys can be engaged with the work that we're doing.
Thank you so much, Kelly, and thank you so much to all of our panelists. We're so grateful to have you share your time and experiences with us. Just want to take 1 minute to talk a little bit more on what Brooks mentioned, which is what we have going on at TJC and at Justice Volunteers. If you are new to Justice Volunteers, a lot of our work falls in 3 main teams. We have a research team that does a lot of work to break down the lack of transparency that surrounds the criminal legal system in lots of different ways. We have a media amplification team that blasts out important messages and framings and things that are happening. As Brooks mentioned, we want to know what's going on the ground and then amplify it from there. And then finally, an action team, which is people in their own communities taking action in lots of different ways to try and really change what's going on in their own communities and their own fellow community members. This is the last webinar that we have in our Blueprint series this year, and it's been an incredible experience to learn from so many experts. I think one of the most valuable parts of it is that after each webinar, there's been a meaningful opportunity for action, and you all have jumped at that chance. So today, one of the things that we are involved with, along with some other partners, is a nationwide day of action that's coming up this Sunday as part of the Free Rodney Reed campaign. I won't give background here, but you can go to freerodneyreed.com for more information. We'll be following up with another email tomorrow. Please, you'll see something pop up on your screen. Just check if you're interested in joining one of our teams or interested in taking part in these actions this weekend. We really hope you do, and thank you so much again for joining us today.
Thank you, Molly. And so now we'll take the last few minutes for questions. And so thank you those who are sticking around. And to the credit of our panelists, you guys have actually touched on a lot of the questions about race and racism. And one question was about Rodney Reed. And so we will follow up tomorrow, as Molly mentioned, with additional information about that. But one question that was posed, and I think Ngozi talked about this a little bit when she mentioned the Anti-Terrorism and Effective Death Penalty Act, is why, when there's new evidence, why does it take so long for an appeal? And they posit that all courts should have conviction review boards. And so any of the panelists who would like to weigh in, please do.
So we talked about some of the kind of procedural barriers that courts have put up over time. And I think the argument that is given is that there has to be a finality in a judgment. And they say, once you are done with your trial, like a jury has heard all the evidence, they've decided. Once you've gotten your direct appeal, which you're constitutionally guaranteed, higher state court, usually the state Supreme Court, has decided. You've had a chance to ask the United States Supreme Court to take your case. It might not have. So when people talk about why there are all these procedural barriers, often the answer is about it just has to be over at some point. We just have to kind of close the books. There are some problems with this, as we've seen, which is that sometimes it takes some time for things to come out. We have had folks who have kind of come out of the woodwork, and interestingly enough, I think sometimes because an execution date is set, there's news media about it, there's stuff that people hear about it. That might be a time when people start coming like, actually, I have information about that. I was on the jury and I never felt good about this thing that happened, that they wouldn't have talked to somebody, even if somebody asked about that earlier. Or, with, innocence cases and DNA, the technology has changed a lot. There are a lot of things that people said were lost and that suddenly got found, which is sometimes, intentional hiding, and sometimes people not being careful enough with the evidence, issues that come up with that. And even if you have the same evidence, but you have new tools to understand the information about the evidence that comes up. So that's how that can happen. Theoretically, there are ways for new evidence to come up. Some states are very strict about that. Virginia is one that for a very long time, even that new DNA stuff couldn't come in. It can come in, but it's still very limited. So a lot of this is it depends on the state, what's going on. And so I would encourage everybody to kind of learn more about what's going on in your local jurisdiction and in your state to kind of know what to be pushing for.
Thanks, Ngozi. And the last question we'll do is, from the stories I've heard, medical care in prison is terrible. So that becomes a death penalty eventually. What can be done?
Oof. I'll talk because I like to talk. I can attest to that. I, at one point, represented folks in prison who were working on health and medical issues. Some things to think about are the amount of privatization of some of those issues around not even just private prisons, but also privatizing medical care. Sometimes states farm that out, and that can have an impact on that. So those are things that you can be aware of going on in your state. I think that there is just more general awareness about the impact that the actual conditions inside prisons can have on both the people that are there, the people that are working there, the correctional officers, and the general idea, if we're saying that this is not supposed to be kind of torture, what that means. So one of the things that has been happening recently around the death penalty is looking at solitary confinement and the impact there. So I think in prison work in general, some of the work has been about litigation that's going to push states to do things differently. And at some point when, litigation is successful, other states will change. And then there's also just been activism around that. So not just about medical care, but there's people talking about toxic prisons and kind of the environmental hazards that people are facing in prisons. And there's a lot of activism around that. So hopefully that was an answer. I'm not exactly sure what the question was anymore.
Thank you. Brooke, I saw that. Were you going to say something as well?
I can speak to that, but I thought Liliana was going to answer the first question, and I was trying to reply that actually.
Oh,
so,
yeah, I did have something to add to the first question, if that's all right.
Go for it.
Okay, yeah, it was just on the mention of a conviction integrity unit, and I just want to say, so much. I mean, I've written a lot about wrongful convictions or questionable convictions, and so much of what you see in states across the country are attorney general's offices that just fight and fight and fight against any sort of attempts to, whether it's getting DNA evidence tested or, winning a hearing to try to prove, ineffective assistance of counsel. I mean, at every turn, that's a huge part of why innocence claims can't move forward. But the other thing is that what I have found is that, even in states that have established conviction integrity units, or what we call it here, conviction review units, when it comes to the death penalty specifically, I've written stories about cases like, for example, in Arizona, where despite major, huge questions in a given case that should actually lend themselves very well to reopening by the conviction integrity unit, they're housed in prosecutors' offices, the same prosecutors who oftentimes have an incentive not to want to revisit these cases because either their colleagues worked on them or something like that. So it's a huge problem. It's a problem in Cuyahoga County that I've written about. It's a problem in Pima County. So I think that we have to really shine a light on, again, to the theme of prosecutors and their power in standing in the way, and including even through these units that in many places have the best of intentions, but fail to take on cases that are really worthy of review.
Oh, and Liliana, could you also talk about Ndulue Abraham? Because that's a case where a local prosecutor was willing to actually take a look at a case and do something, but still there's, more stubbornness.
Yeah, it's kind of an astonishing and really infuriating case. This is a case of a man named Abu Ali Abdurrahman. He actually has been on death row since, I don't know, the mid 1980s or so. I won't get into, all the questions around. There's a lot wrong with this prosecution. He's a Black man who was prosecuted by a man who is no longer a prosecutor in Nashville. This is where I am in Tennessee, in Nashville, but who is still practicing one county over. And essentially, among the many, many problems in this case was that this prosecutor used pretty overtly racist stereotypes in trying to remove, disqualify potential Black jurors from the jury pool. This has been part of the challenges to Abu Ali's case for years and years and years and years. And finally, we have a DA here in Davidson County in Nashville who is actually kind of progressive and sympathetic to these issues. And so a couple months ago, basically, the Davidson County DA, with the collaboration of the victim's family, came up with an agreement, and Abu Ali's attorney decided that they would agree to stop standing in the way of the challenges that Abu Ali was making to his death sentence if all parties could agree that his sentence would be commuted to life without parole. And there was a hearing before a judge where they discussed this. The Davidson County DA talked about how racism in jury selection is indefensible. It's a relic from an era that we should strive to leave behind. And it was a really extraordinary sort of event. Abu Ali was there, and so were the victims' relatives. Except for then, immediately, the Tennessee Attorney General decides that this is intolerable, and no, this deal that's been struck with the cooperation of all sides is improper in some way, and basically has been appealing this decision ever since. They're saying that the judge and that the DA abused their discretion to come up with this arrangement, and essentially, the Attorney General is trying to fight to reinstate Abu Ali's death sentence. This is a man who was set for execution in the coming year. So that really speaks beautifully to the way in which attorneys general will fight, dig in their heels, even in cases where, it just seems to serve no rational purpose anymore. But it's part of what's going on right now in Tennessee. And we're a state that's executed 5 people since summer of last year, 3 of them in the electric chair. So sorry to end on a grim note, but that's what's up here in Nashville.
No, Liliana, thank you so much for that. And we're actually getting more questions from our attendees. So one that was just asked was, if a method of forensic science is discredited, shouldn't there be an automatic reopening of a case, at least an evidence review? And she specifically notes bite marks. And I know there's also fingerprint and blood typing. So if you guys want to weigh in on that.
I'll jump in very quickly. Should there be? Absolutely. Will there be? No. There's almost nothing automatic. So you have to take that thing that you see in movies where it's like they're in the courtroom and they go, wait, somebody, like I think literally in a capital case, you could be in a courtroom in an appeal and somebody could walk in and be like, I did it. And if you didn't follow the procedural ways to get into court and jump over all the procedural orders, the court won't care. You could be at a place in your case, I think it's possible, you could be in a place along your appeals when evidence emerges conclusively showing your innocence or showing somebody else did it, let's say. Depending on where you are in your appeals, that may or may not be able to come in at that point. You probably have to find this other constitutional hook to bring it in on. And that's a lot of what Ngozi and Liliana were talking about with the AEDPA, the anti-EDPA, I'm not even gonna try to say it, the Anti-Terrorism Effective, it's such a terrible name, the Anti-Terrorism and Effective Death Penalty Act. Anyway, that's a lot of what that did. So unfortunately, you are absolutely right. We should live in a country where anything like that shows, we relied on this evidence and now that scientist has been discredited, the case should be reopened. That seems like common sense. Mr. Hinton was mentioned Ngozi mentioned Anthony Ray Hinton's book, The Sun Does Shine. Mr. Hinton was freed by work of Equal Justice Initiative after 30 years on death row for murders he did not commit. What a lot of people don't realize is that I think after about 12 years, the evidence, the ballistics, the faulty ballistics evidence, EJI had it retested. By the 3 top forensic experts in the country, and shown that not only did it not come from the gun at his mother's house, the guns used in the 2 murders didn't even come from a single gun. They fought for 18 years to get that back into court. It took 18 years to get that officially retested by the state, at which point the state didn't issue any kind of real exoneration. When the United States Supreme Court miraculously overturned it, the state just dropped the charges. That's what we're up against here, and that's why it's so important that all of these things, this is something that we should actually be making a point of in terms of what people can do. All of the things happening on the front end about policing, arrest, prosecutor discretion, jury discrimination, all of those things, the reason they are so critical is it's not like the movies. Once, and Derrick knows this, once you get convicted and sentenced, it's very, very difficult to get any change at that point. So, unfortunately.
Yeah. Yes, indeed.
Derrick, I'm sorry, were you going to say something?
No, I was just saying yes, indeed, of what he was saying.
Mm-hmm.
You know, when you was younger, your mom said it's easy to get in trouble, but it's hard as hell to get out of it, you know? And that's what it felt like, you know? It was like, man, the courts move at a snail's pace, you know? It took me 17 years to get some action in the courts, you know? So that's a long time. I went stay at executions while I was on Ohio death row. They came to kill me 6 times, y'all. That's a thing. One time is too much. They came to kill me 6 times, and I'm still here, you know? So, wow. You know, we got, I hear people talking about our justice system. We got one of the best justice systems in the world, hands down, but it's broken. You know, when you're dealing with human beings, you're going to make errors. And you make a lot, with having the death penalty, you're making a lot of errors because you make a mistake, it's going to kill that man or woman or child, you know? So, with that being said, you know, I hope one day we can all have a discussion about the death penalty in the United States. That would be a great day for me because, you know, they killed all my friends, you know? All my friends, them guys, I knew on something for like 20 years, you know. They all gone now, you know. And someone was innocent, you know. And they just didn't have the money to prove they're innocent. You know, people talk about the death penalty. Only poor white people, poor blacks, and poor Hispanics get the death penalty. Like Sister Helen Prejean from Dead Man Walker said, people with capital don't get capital punishment. So with that being said, it's a bias against poor people, you know. So, you know, if I would have knew what I knew now, you know, because I went in there with a public pretender, you know, and I didn't know. You know, I didn't want my people to spend their money because I knew I didn't have nothing to do with the case. So I told my people to bag up, you know, let the public defenders handle this. And that was the worst thing I could have did, you know, because them public defenders were going up against the top prosecutor in the state of Ohio, Mark Priemeyer. Google him. He got all the top cases all over Ohio. They bring him out for all the big cases, you know. So this didn't just happen to me. He did this to like 15 other people. So I'm glad to be on the panel, and that's all I got to say for right now. Thank y'all so much for having me.
Thank you, Derrick. And so our actual last question is, how do we get presidential candidates to speak to this? And I will also add in other actors in the system from, we've been talking about prosecutors and mayors and governors and AGs, and, how do we get system actors to speak up on this?
I'll jump in with the really, really, really super quick and just jump out, which is like anything you first to say, it can just seem so big it's not worth doing anything, but any pressure you can put on them to let people know you're paying attention can be helpful. That's all.
Yeah, I'll echo that. So I think right now, I think all of the primary challengers have made some statement against the death penalty. But I think that when you put it like, and I like what Liliana talked about when people kind of put the federal death penalty on a pedestal and see it as something separate, like really thinking about what is happening kind of like on the state and local level is so important. So having those conversations, and we talked about how this tough on crime conversation was the thing in the 90s, and now we're having a different conversation, and prosecutors are feeling pressure not to be tough but smart on crime is what some people are calling it, and just actually doing things that are focused on public safety and less just about, how much punishment we can add on. That is what is so important for that is kind of public opinion and public speaking out and recognizing that these issues are important. And I think that question about what do you know about the way that criminal justice is being or injustice is being administered in your, state or local government, and what, like concrete actions can you do to push for changes about, whether the procedure's right, whether there are ways, and people have done kind of innovative ways to actually try to get more justice, thinking about what are ways that we're addressing juries discrimination. How are we actually choosing juries? Are we talking about, bias and implicit bias and explicit bias? So I think getting as educated and as involved as we can, and making sure that people know that people care about these issues. For a very long time, criminal justice, either, first it was tough on crime, then it was nobody really cares about that. Well, people care about that, and you all are here today because you care about that, and making sure that the folks who have power in this recognize that this is an important issue for you is always important.
Ngozi, thank you so much. And thank you, Brooks, Derrick, and Liliana as well for being a part of this panel. To our attendees, thank you for sticking around for so long and for asking such amazing questions. And so, as we mentioned before, this is our last panel. This is our last webinar for the year. But as we plan for 2020, it is incredibly important that we hear from you. And so we want your feedback, we want your ideas for our webinars, and we want your questions about these issues that we've spoken about. So please email us at volunteer@thejusticecollaborative.com, and we're going to follow up with an email tomorrow with that email included. And so we really do want to hear from you, and we thank you so much for all the work that you do. All right, enjoy the rest of your day.
Thank you.
Thank you. Bye.
Okay. Bye-bye, y'all. Bye.